One, we ask that everyone turn off all cell phones and other electronic devices. We live stream our oral arguments, and the microphones and cameras have been turned on.
You know, retirement for us?
Yep, for 10 more minutes.
I was just telling you, I was wondering if you were gonna come out for this.
This is the last day. Check it off the list.
Yeah.
Good way to end it. Hey, how do we want to treat the last 5 minutes? Do you guys want to?
I'm gonna argue everything.
Okay, but
From-
the court said something in the order about splitting the rebuttal time between the different appellants, or two appellants.
But their cross appeal might be.
That's no big deal. Don't worry about it.
All rise. Hear ye. The Honorable Presiding Judge Greer and Associate Judges Mueller and Langholz of the Iowa Court of Appeals. The Iowa Court of Appeals is now in session.
All right, we have 3 cases to hear today, and the first one we're going to start with would be 250332, and we have, I think, Keisha Douglas will be arguing for, let me get this straight, Old Town, we're going to call it Old Town Roofing, or as the briefs say, OTR. Yes, and then we have Kevin Castor arguing for, and could you pronounce your clients' names, please? Fowlkes, thank you. And so whenever you folks are ready, we're ready for you. Yes.
Counsel. On appeal, Old Town Roofing asserts the district court got one factual issue wrong, which in turn caused a faulty legal conclusion. The one factual finding Old Town Roofing takes issue with is the district court's finding that Old Town Roofing failed to prove that it removed the old existing roof after execution of the December contract. However, on appeal, the Fowlkes have now clarified that they've never taken that position. This clarification and admission makes this court's decision on Old Town Roofing's claim for error much more simple. The erroneous factual conclusion made by the district court caused the district court to conclude legally that Old Town Roofing failed to prove it substantially performed its contractual obligations and thus could not enforce its mechanics lien. Accordingly, if this court agrees with the district court's contractual interpretation and construction, which it should, then Old Town Roofing's requested relief should be granted, as the factual error complained of is now undisputed by the parties. On the flip side, on cross appeal, the Fowlkes assert the district court essentially got everything wrong except for one immaterial issue. The immaterial issue being that the district court properly viewed the December contract and the October contract as one contract and not the December contract superseding in full the October contract. In arguing the mechanics lien claim and counterclaim, the Fowlkes blur the lines between the two standards at issue, the equitable standard of review, which is de novo, and the legal standard of review, which is for errors at law. The majority of the Fowlkes' arguments concerning their counterclaim argue the weight of the evidence and the factual findings made by the district court, which is improper and not grounds for reversal. The Fowlkes essentially have failed to meet their burden on appeal of demonstrating any errors of law made by the district court and or any factual findings made by the district court that were not supported by substantial evidence in the record.
To your claim and your first point that the district court made an incorrect factual finding, what specifically is the evidence in the record that your client did remove all of the roof that was left to be removed after the signing of the new contract?
Mr. testified to that, who is the president of Old Town Roofing. Chris Reed testified to that, who is the vice president and who was visiting the job site very frequently towards the end of the project, especially after the December contract was executed. He was involved in the execution, the preparation and execution of that, and then he essentially took over that job management from there. And so he testified to that as well. Obviously, we have the judicial admissions. That is a bit of an issue, but now I believe that issue is moot because there is now no dispute because the Fowlkes have stated that they don't take issue with that and they've never taken that position. But even if the court does agree with that or does review the judicial admissions made by Mr. Fowlkes, he very clearly testified that after the December contract, Old Town Roofing removed the entire roof. But again, I think the judicial admission issue that was originally briefed is now moot because that's been cleared up and clarified that that's not at issue. And so I think there was a lot of confusion at trial about what the evidence was and was presented. And I think that's what led ultimately to the district court's faulty factual finding that there was a lack of evidence regarding removal of the roof after the December contract.
A little bit more about the standard of review, because the ordinary rule is that when a law action and an equity action are tried together to the bench, it's all reviewed as an equitable action. Why wouldn't that be the case here?
Well, if you review the district court's record, the district court did state it was accepting the evidence into the record for equitable purposes, so it would be in the record, but it was taking the objections and applying those objections and legally to the law claims. So I do believe that the court was applying those different standards at the bench trial, and I believe the parties agree in their briefing that the standards of review are different for the two different claims.
Case law is that when the actions are tried together, you can't do that kind of hybrid parsing. It's either all equitable or you have to try them separately. Why wouldn't that be the case?
I don't have a case in point off the top of my head. My understanding of the case law was the opposite, that the judge would accept the evidence and then parse it out depending on the claim that it was considering.
Let me ask you this. Then do you have a case in which the court has done that hybrid parsing with actions that are tried together? I understand there are cases where they are tried separately, and that's a lot cleaner. Here they were tried together, right?
And I think part of that, you see, I don't have a case, I'm sorry, right off the top of my head, because that really wasn't an issue that was raised by opposing counsel in the briefing. But there are some case law I recall reviewing about dealing with objections in equitable claims and law claims that are being tried together, and what the procedure is for allowing that evidence in and the limited purpose for allowing that evidence in.
Following up on Judge Buller's question, just practically, I'm having trouble getting my head around how it would work on claims like this, where the issue, and especially the basis for deciding it, was essentially like the same factual issue, where we would be giving extreme deference, doing a substantial evidence review under correction of errors at law, but de novo being able to sort of do it ourselves. It seems to set up a kind of untenable situation where we could be coming to the exact same decision, in opposite ways. How would that work through, here if you're right that we can split it up and do both standards of review?
Well, I think that, of course, the facts are very, very much overlapping, but I believe that the claims at issue and that are being argued against on appeal are different. Old Town Roofing is essentially stating, we performed the contract, and this is what the contract says, and this was the intent of the contract. The December contract was prospective. That was the intent of the parties, and that was testified to by Mr. Reed and Mr. Fowlkes, and we substantially performed to the extent not prevented. Now, on the flip side, the Fowlkes argue different. They say Old Town Roofing breached, and that's why we kicked them off, and the breach occurred prior. So I think that the issues are distinct, although the facts are overlapping, but I think the issues are distinct, and so I think that this court should be able to apply the different standards because they aren't substantially overlapping legal issues, if that makes sense. For instance, the Fowlkes claim that there's poor workmanship and that the roof was unwarrantable. And that's not really an issue that Old Town Roofing claims with regard to their mechanics lien claim. They argue about a lack of diligence. We didn't do things in a timely manner. That's not really something that Old Town Roofing is raising in enforcement of their mechanics lien claim. So those, I think, issues are distinct and can probably be decided distinctly under the distinct standards. And so I want to direct the court's attention to the intent of the December 2020 contract, and I want to focus in on the the trial testimony that was at issue. Docket entry 352 was Mr. Reed's trial transcript, starting at page 26, line 24, through page 28, line 15, and he talks about preparation and purpose and the intent of that December contract being very prospective only. He was very clear about that. The next day, Mr. Fowlkes testified as to that same subject matter, and that's found in docket entry 354, transcript page 160, starting at line 18 through 163 at line 1. And essentially, Mr. Fowlkes testified that the purpose was so that, quote, they could move forward and everyone was on the same page. So even Mr. Fowlkes indicated he understood the purpose of the December contract was to clarify and be prospective about what the terms and the scope of work for Old Town Roofing was moving forward. So I think that the district court got it right with interpretation of the contract. Nobody disputes the law in the principles that were cited by the district court in coming to its contract interpretation issues. And so I believe the underlying facts are pretty much undisputed. It's just how those facts are applied. The folks want to view that December contract in a vacuum without reference to the party's intent and without reference to the circumstances surrounding preparation of that contract, which this court cannot do. And I know my
5 minutes on rebuttal, so thank you.
Thank you.
Mr. Castor, whenever you're ready. Question for you, though, by the way. So I have trouble with the substantial performance issue where Mr. Fowlkes then 10 days later tells the insurance company it's done.
When Mr. Fowlkes tells the bank, not the insurance company, that it's done for the purpose of having the bank release insurance money that the bank is holding in escrow, he says it's done because the roof is now watertight. And he was asked to, in his redirect examination, he was asked to describe why the roof could be done for the purposes of getting the release of the insurance money, but not done for the purposes of the contract between the Fowlkes and Old Town Roofing. And the answer is pretty clear. He was concentrating on getting a roof that was watertight, and for the purposes of insurance, that's all he needed, he believed. Now, whether that's what the insurance contract required or not, that's not in the record. There was never any examination about whether the insurance policy required something more than just watertight. But in his mind, for the release of the insurance money, he believed the roof was complete when he made it watertight. But in his mind, additionally, he still believed that the roof, and later found out that the roof did not conform to the contract in many different ways, besides the ways that he had to complete himself. And that includes the failure to get a warranty from the manufacturer, the failure to get an inspection from the city, and the fact that they roofed over the roofing materials that were supposed to be torn off, all things that he found out later. Nevertheless, so he can, with a straight face, come to the court and say the roof was not complete as judged by the contract between the Fowlkes and Old Town Roofing, which contained the specifications laying out what completeness required.
Warranty require a certified installer?
The warranty did require a certified installer. It required a great deal of other things as well. So there's no way that Mr. Fowlkes on his own is going to get a warranty by himself, unless Carlisle manufacturer sends somebody out there and they excuse the lack of a certified installer for the last part of it. The person who was the representative for Carlisle came to the court and testified about his visit to the property, but he characterized his visit not as an inspection and says that Carlisle Roofing never came out to inspect the roof, and therefore we don't know whether or not Carlisle would have approved the roof for warranty purposes or not.
You to the standard of review issue I was discussing with your opposing counsel earlier. I know in your brief you say it's correction of errors at law for the second issue. Do you know of any case law that say we couldn't split it that way?
I don't know of any case law that says that we can split it. The case that we did cite in our brief, as I recall, seemed to be a kind of a case where, as you describe it, the two issues were sort of tried separately in the same trial, and they could tell which one was equitable and which one was legal. That's the only case that we're aware of. If the court's aware of other cases, we're certainly happy to try to supplement the record if that's something the court's open to, but it sounds like you've already done that research, so.
Typical fact pattern is we get a record and it's not clear if it was equitable or at law, and we're trying to figure out, is the court ruling on objections, what exactly is going on here? This is a little different than that, though, right?
It is different because although the court ruled on objections for those purposes, and the court seemed to be keeping track of those objections, clearly the same facts apply to the equitable part of the case and the legal part of the case. It's the same issue of whether there was compliance with the contract. And that goes to the tear-off, it goes to the diligence with which the contractors performed their duties, and it goes to the details that were required by the Carlisle Roofing Manufacturing. So OTR breached this thing in a number of different ways, and the first breach that I want to focus on is the tear-off. The original contract obligated them to do a complete tear-off, undisputed. Nobody doubts that. We aren't here to dispute that or resolve that. And it's undisputed also that OTR did not tear off the old roofing materials between the original contract in October and the new contract in December. Undisputed. Nobody doubts that. The court found it, and then that's not in dispute here. That's a breach of the first contract. That is a breach of the first contract. All we're here to decide is whether or not the second contract applies in a way that excuses the prior breach. In other words, that it applies prospectively only. Now, it may seem frustrating at this level of review that there's not more record on whether or not work was done after October or after December on the tear-off. But at the time of the trial, we had no idea that this was an issue. It was never raised in any pretrial brief. You can read both of the pretrial briefs that were submitted by Old Town Roofing. It's not raised there. And it was only raised by two questions of one witness on the second day that were, let's face it, leading questions by their counsel. That's all the record that you have with respect to what the intent was of the parties on whether it was prospective only. And with respect to counsel, the quoted section from Mr. Fowlkes' testimony about whether he intended it to be prospective does not say what counsel says it says. Mr. Fowlkes did not testify at any time that he intended this to be prospective only. His only testimony on the issue is that when asked about the December revision, did you intend to have the words complete tear-off in there? And he said yes. Again, admittedly, the record could be more developed on this point if in hindsight we knew that this was going to be such a big issue. We just didn't know it at the time.
Counsel, as I read your brief, the focus of your argument sort of is on the district court's interpretation of the contract and whether this should matter, you know, that we have to focus on only the prospective piece of it. If we agree with the district court's interpretation, does that mean you lose? Or I don't read, you know, sort of, at least on this issue, I don't really read or see sort of what your argument is if we agree with the district court's interpretation, that it is prospective only and that it does matter whether you proved that everything came off just after the new contract or the modified contract.
If you agree with the district court's interpretation of the contract, that the requirement to tear off materials from the prior contract was excused because we know that they failed to breach it then. And that's the effect of the prospective only interpretation. If you get that far, then the district court is correct that there is no evidence about how much of the tear off took place after December 23rd. There's nothing we can do about that. We didn't know that was going to be an issue. But I can say further, the district court makes another error here, which is on the burden of proof. The district court now is saying that the requirement for the tear-off that was breached between October and December is excused by the December revision of the contract. Excuse is an affirmative defense. That, and so is waiver, which the district court also hypothesized about in a footnote. Those are things that they have the burden to prove. And so the failure to have evidence about whether the tear-off occurred before or after December 23rd is a failure of their proof, not a failure of our proof. It seems like cutting a thread very finely there, but this is an unusual case, and this idea of equipoise is really an interesting way to sort of split the outcome, if you will. But there's another reason why this interpretation is wrong, besides the fact that the district court dismissed the importance of the word complete in the contract. There's really, in our view, no other way to read it. Complete means all, according to the testimony of Sean Vogler. That there's also just no evidence that Mr. Fowlkes agreed to this. Maybe Mr. Reed intended this, but if it's his secret intention that's never communicated to Mr. Fowlkes, and it certainly wasn't communicated in the language of the contract, it's then not an agreement. It is not an agreement by Mr. Fowlkes. Mr. Fowlkes didn't testify that he agreed that it was prospective only. You won't find that anywhere in the quoted or in the referenced pages that were just talked about, and you won't find it anywhere else. He was only asked about it once, and he said, I agreed with the term complete tear-off. He was only asked about the contract revision once, the words complete. But more importantly, and this is perhaps the most important point I can make, none of the other terms in the December 23rd contract were interpreted as prospective only, as excusing work that had been previously done. For example, one of the key terms in the December contract was use a PVC membrane. Well, the parties knew they had already been installing a PVC membrane. That had been the oral argument or oral agreement of the parties from the beginning. Clearly, the other terms of the contract applied retrospectively. And in fact, Mr. Vogler, the president of OTR, admitted that in his testimony. Let me get you a specific citation to that. He says, he testified about all terms in the December 23rd contract, and he said, this is referencing the actual work that was being done. This is in the transcript of volume 1, day 1 of the trial, page 46 of Mr. Vogler's testimony. I wish I could cover more, Your Honors, but thank you.
Question, though. The contract in December didn't reference that other addition of the roof, the sump thing. So wouldn't that work against your argument there?
It's perfectly consistent with that argument. Although it's an omission from the December contract, and that work had already been done, it did not excuse Old Town Roofing from performing the work that they had already done, and didn't prevent the folks from making a claim that that work should be done right, and it didn't change the price of the contract, which included that work.
Very much. All right, rebuttal, please.
I want to address the first contract first. Mr. Castor raised an issue about breach of the first contract, and Old Town Roofing didn't remove the roof based on the first contract. But everybody agrees that the first contract didn't adequately describe the scope of the work that Old Town Roofing was doing. And so there's no dispute about that. So how can you breach a contract that doesn't accurately describe your obligations? I'm unclear with that. And that was the reason for the December contract. There was miscommunications, misunderstandings about the scope of work. Mr. Reed very clearly testified why he didn't include the sump pump information in the second contract. And he said, I didn't think about it because it was already done. And then when I asked Mr. Reed about the complete tear-off term, he said, I said, okay, so complete tear-off of roof, that first line item, that was what Old Town Roofing was going to do on or after December 23rd, 2020. Is that correct? Yes. Question, meaning it didn't contemplate Old Town Roofing going back and tearing off the roofing underneath the framed out sump pump room. Is that correct? Correct. Mr. Fowlkes had the opportunity to come in and testify to something contrary about the conversation, contrary about the intent, but he didn't.
Complete means in the contract.
So my understanding, based on the evidence, was that before the December contract, there were portions of the roof that were completely removed by the derecho. And so the old roof had to be removed in some areas, and they did remove the old roof in some areas they did not. So, and then they were overlaying. And so I think it was clarification that you're not gonna just selectively remove parts of the old roof, you're gonna remove the rest of the roof for the remaining work. But the December contract clearly doesn't explicitly require Old Town Roofing to pull up the sump pump room and remove the old roofing underneath. If that was the intent, I would have expected that to be in the contract, but it wasn't. And Mr. Fowlkes had the opportunity, the blank form was brought to his office, both Mr. Fowlkes and Mr. Reed testified that Mr. Reed came to his office at the Scratch and Dent building with a blank form. They talked about it, they talked about the scope of the project, and Mr. Reed filled it out in front of Mr. Fowlkes, and Mr. Fowlkes had the opportunity to provide input into the terms of the contract. And his failure to insist on provisions of pulling up completed portions to remove the roof show an intent for prospective only. These are the facts and circumstances that the court is required to consider in determining the party's intent. And so, along obviously with the testimony and the conversations, and again, Mr. Fowlkes didn't require, provisions and allowed Old Town Roofing to continue to do work despite the delays, despite the fact that he was very much aware that some of the old roof was not removed. And so that again supports a prospective only interpretation. If he didn't intend to waive or modify the contract with those terms, they would have been in the contract, but they weren't. And so that shows the intent of the parties.
Argue that tear off complete roof except for that has already been done would have been your interpretation.
I agree it could have been worded more artfully. I think everyone can agree that it could have been worded more artfully, but that's why the courts require in interpreting the intent is to look at the surrounding circumstances and look at how the contract was prepared and under what circumstances and the conversations that were being had and the reasons for the preparation of this additional contract. And I want to touch briefly just on the public policy arguments that were made by the folks on treatment of the property as that should have been treated as residential. The folks have provided this court with no legal authority, in my opinion, to support the fact that a contractor should have a crystal ball or should be clairvoyant to understand that someone's secretly living in a commercial building that's zoned commercial, that's identified on public records as industrial and warehouse. There's just nothing in the public policy that should require a contractor to have that level of understanding without being objectively told that information. And my time is running short, so I appreciate your time. Thank you very much.
So thank you for the excellent briefing that we received from both sides, and also the arguments today were very helpful. So please consider 250332 submitted, and my colleagues and I will get a decision out as soon as we can. Thank you very much. All right, we next have 250664, State of Iowa versus Anthony Cotner Jr. And Teresa, Ms. Wilson, you will be arguing for Mr. Cotner, and Mr. Kenworthy, Adam Kenworthy, you will be arguing for the State of Iowa. So, whenever you're ready.
May it please the court. I'm representing defendant appellant Anthony Cotner Jr., who was convicted of sexual abuse in the second degree following a jury trial. The issue before this court is whether it is categorically inadmissible hearsay when a defendant attempts to testify as to his conversations with the complainant during the incident that is the subject of the trial. Before getting to the merits of the issue, however, I want to address the question of error preservation. CS was permitted to testify as to what both she and Mr. Cotner said during their encounter, including the defendant's statements as to or questions as to where she was going and his commands. She claimed that she told him to stop and denied giving him her number, talking about seeing him again, or having any other discussion with him. Mr. Cotner tried to push back against her version and her claim that she was not trying to engage with him. He testified to exchanging highs, and the state objected to the question as hearsay. The defense attorney responded that it was not being offered for the truth of the matter asserted, and greetings generally are not. But nonetheless,
Clarifying question there, because the word necessarily, I know it was omitted from what you just described. Isn't there a difference between not offering it for the truth or not necessarily offering it for the truth?
in this case, no, just based on context. Plus, again, greetings are not assertive. They're not statement of facts. They are not considered hearsay.
What does necessarily mean in that sentence then?
It's probably just the way the attorney was speaking to the court. I don't know that necessarily has a meaning there. But after that, the court sustained the objection and specifically said, you can only talk about what you said. You can't report what she said unless a hearsay exception applied. There was an unreported bench conference, and from that point on, the transcript is very clear that the defense attorney tried to constrain the defendant's testimony, repeatedly saying, without saying what she said, don't tell me what she said, but under Rule 5.103A2, to preserve error regarding excluded evidence, a defendant must inform the court of the substance through an offer of proof unless the substance is apparent from the context. Now, I'm not going to suggest in any way, shape, or form that the record created below was ideal. It wasn't. But in this case, it was good enough.
What was the substance going to be? Do we know exactly what the statements were?
Not. What we do know is that the defendant was restricted from testifying regarding any statements made by CS. And so this is a little bit different than what we normally see with most hearsay challenges and offers of proof. Oftentimes, it's a very specific thing that a party wants to get into evidence. Maybe it's a video or a prior one or two statements. And therefore, it's very easy to make an offer of proof as to those particular statements. Here, it is the entire context of his encounter with CS and the conversations inherent in them. Those conversations go directly to what he understood or his state of mind as to whether his association with her was voluntary. In order to get all of that information in the record for the purposes of an offer of proof, we would have to do essentially what district courts don't like to do, which is have a trial within a trial. Put the defendant on the stand outside of the presence of the jury and let him testify as to everything.
All the time.
Not to the extent it would need to in this case. It would have to be essentially his entire testimony. The state would have to put their specific objections on the record. The defense would have to put their specific responses on the record. And the one thing that does, aside from creating a trial within a trial, it gives the state a preliminary view of the defendant's case.
So why couldn't there be a narrative offer of proof then? Or a documentary offer of proof, file a pleading that says, I expect my client will testify, blah, blah, blah. I mean, there's multiple ways to make an offer of proof, and interrogatory isn't the only way.
True, but Rule 5.103 says if the substance is clear from the context, and what is clear from the context is he was going to testify as to her statements that would then impact, number one, her credibility, and number two, the effect on the listener, him, that if that substance is clear, you don't need an offer of proof.
Why don't we need to know exactly what the statement is to understand? I mean, your argument about High is that this was not offered for the truth of the matter asserted, and I could envision a lot of different statements that he said, she made, that could be of different characters. I mean, how do we do the hearsay analysis just kind of on this theoretical level?
When it is being offered for the effect on the listener, as in Elliott, and when it is being offered for impeachment purposes, and I'm not talking Rule 5.801D2 or whatever it is, the prior and consistent to statement under oath, you have a right to provide the contradictory statement of the opposing party. And that's, under Wyckoff and other cases. So it's not hearsay. If you understand that the entire testimony would be with respect to those two issues, it's not hearsay.
On how am I supposed to rule on whether it was hearsay without knowing what the statements were?
I think we have to go with the fact that the court issued a blanket ruling. The court didn't necessarily care what the specific statements were. The court said, anything she says is hearsay. I mean, not a direct quote, but that's essentially the ruling of the court. That is categorically wrong.
But I'm not sure it is when you read the next sentence, which says, unless there's some exception that your counsel implies, I guess the court probably meant said, and we would have to decide that. So that sounds a lot like a whole lot of rulings I saw in the district court, which are, this is tentatively excluded. If you've got a rationale to bring it in, let me know and I'm gonna rule on it. What am I missing?
Interpret that is the court had already ruled all these statements are hearsay. So when the court refers to unless you have an exception, what I interpret the court as saying is unless you have an exception to the hearsay rule, which by definition means all those statements are hearsay. It's absolutely consistent with this categorical approach.
So I think your reading would require we assume the district court knew the difference between an exemptions and exceptions to hearsay, which frankly I think a lot of lawyers don't understand. Is that a correct assumption baked into your comments?
I would certainly hope a court would understand the difference.
I'm with you on hope.
But the fact of the matter is this was a categorical ruling, and it impacted the defendant's ability to present his defense.
On the merits of High, which I think is properly before us, the state argues that was an implied assertion, and cites to some authority for that. Can you sort of respond to that argument, that that the High was impliedly asserting sort of the nature of the encounter?
I've provided authority that says greetings are not considered hearsay. They would not be an implied assertion. An assertion of what? Hello is not an assertion. It's a greeting. So I don't think it gets in under any sort of implied assertion. And the state argues, let me get back to, the fact of the matter, if jurors are going to determine consent, they need to hear both sides of the incident, both versions from both parties. The jury didn't get to do that in this case. I see my time is up. Thank you.
Rebuttal. Mr. Kenworthy?
May it please the court, counsel. I think I'll start where I think the court's questions are kind of hitting on two major issues we have here. One is the issue of, both issues are record. First is what was discussed at that bench conference. And second, what were Mr. Cotner's questions, what did he want to elicit, what type of testimony, and for what purpose? And so for both of those, we needed a record of what did the parties discuss? Because I think, as the court pointed out, you see that kind of happen where the court makes this ruling where Mr. Cotner's asked a question, didn't really ask him to say what he said, but what he did. He responded with, I said hi, she said hi. The state objects. Again, on the transcript, it's hard to tell. I think we say in our brief, it's very possible, given the way a trial works, that the state was maybe trying to cut off any further testimony, so even conceding if hi should have come in, which as we briefed, it did later. And the court never struck it, so technically it did come in. But then the judge makes a ruling that I think as we point out, is incorrect, but mostly incorrect in favor of Mr. Cotner, saying you can testify substantively about what you said, but you can't testify about what CS said. And then that's when defense counsel says, I'm not offering it for the truth of the matter necessarily. The party's approach, we don't know what's discussed there. I think earlier in the trial, this can kind of help elucidate some of this. There was a bench trial earlier, I think during the officer that was doing some of the, I want to say Thompson, that could be incorrect, Officer Mitchell's testimony, the second day, volume 2, where they had an objection to hearsay, the defense counsel raised it, there was a bench conference. 2 witnesses later, the court says, let's make a record on what happened at that bench conference. The court kind of covers what his understanding was of why it was being offered by the state for responsive conduct, not truth of the matter. Defense counsel asked for a limiting instruction, the court granted it. So the parties understood kind of how to make these arguments, how to put things on the record. And I think what's interesting here is there could be a calculation by Mr. Cotner at trial to not make a record and to use this kind of erroneous ruling in his favor because it was helpful to him. The fact that the court saying, you can testify substantively about what you said, actually that's hearsay unless he can offer some sort of reason around it through, he's not offering it for the truth or there's some exception that applies. But him just getting to blanket testify, I told her this, is actually hearsay. The state didn't make an issue of it, so it all came in. But I think as you read through the transcript, you see that Mr. Cotner then was able to testify about what he said, and technically assertions still are hearsay, and many points throughout the transcript of his testimony, the state didn't object. But while Mr. Cotner couldn't say exactly what CS said to him, the way the questions were asked and leading questions were, did it look like she wanted to have sex with you? Yes. Did she act like she wanted, she was enjoying this? Yes. Did she tell you her name? Yes. Did she tell you where she lived? Yes. So he was still able to cover all of this same territory. And as counsel's arguing, they weren't asking for the witness, CS's testimony to come in substantively. So if it was going to come in for effect on the listener, it really doesn't matter what the exact words were because it couldn't come in substantively. So the same things came into evidence, the same kind of consensual responses. It was clear from the record that Mr. Cotner was able to say he believed the encounter happened one way, contrary to the way that CS testified it happened. And then that became a weight issue for the jury to kind of determine. But I don't think there's any way to show that he was limited in what he wanted to get into or any of his defenses. But again, I think to the extent there were specific testimony that he needed in the record for some reason, that did need to come in through an offer of proof. And again, that happens all the time where a witness with expert witnesses, that happens where you'll have a huge amount of a transcript that'll take up large portions of an offer of proof. And that's just kind of the way it's necessary to move forward to preserve those issues so the court can determine. Because while a defendant or the state, while any proponent of testimony might say, I'm only offering this for effect on the listener, the court still has to say, okay, is that right? Maybe they're not, but they're trying to get it in substantively. And if so, that doesn't just automatically get it in, because then there's still 403 where the other party could still say, yeah, okay, but it's still more prejudicial than probative, or it's not relevant, or it's cumulative, and the court could keep it out for some other reason. But those issues all need to be put on the record for this court or any court to review.
About high and the implied truth. Dollard's an odd case. It includes directives that we sort of look beyond the plain language of what the statement is. What is the state's position the implied truth of just high is?
So going off of, again, the absence of the record at the bench conference, the state objected to high. I think under Dollard, to show that it was consensual, she was responding high as in responding to his greeting. It's an implied assertion, I think, under Dollard that could be hearsay. I think, as counsel argues, usually under the federal rules, it is considered not. Dollard is kind of a different case for Iowa. So again, I think it could be used to say this is an assertion of, I think there's cases from our court that say even like a head nod could possibly be an affirmative assertion. So it's possible that was, if it's going to show, yes, she was saying hi, she was engaging and not actually she meant hi. Again, not the hill that probably determined the whole trial here, even if that should, like I said, it did come in actually and it wasn't stricken, but on that kind of detail, I think it does become a little more difficult to go down that whole road of is every high hearsay? And again, I think just reading, again, this is not our lack of record, but I think reading a little more into the transcript and how trials sometimes go, it did seem, I think, possibly that the state was trying to cut off any further issues there. But again, we don't really know what was discussed at that bench conference. One other issue I'd like to move into is something that was raised at the end of Mr. Cotner's brief, and that had to do with this issue of the constitutional issues and whether those were raised or how those harmless error would be applied. And I think there's two problems there. First, Cotner switching his argument from, I think the whole part of the brief is none of this was hearsay and the court should have let it in for other purposes. But then it moves to, but I have a constitutional right to present hearsay evidence. So either it was hearsay and then we get into this idea of chambers and whether this was necessary for the defendant to be able to prove his defense. But regardless, all of that still had to be raised. I think the position in the reply brief is no, the court can on its own decide whether it wants to apply a constitutional harmless error lens. But I don't believe that would be correct because that would pretty much take any issue and the court would just be able to frame, if they think it's a constitutional issue they want to take up, they can examine it there. I think still below, the issue has to be raised, the constitutional objection has to be made. Your Honor, if you don't allow this testimony in, it's violating my client's due process rights or his right to a fair trial, overruled. Okay, now on appeal, this court can apply whether there was a constitutional violation, and if so, was it harmless under constitutional harmless error analysis? Without raising the constitutional issue, I don't think the court on appeal can say, but we think on our own, we should get into the constitutional argument here. I don't think that is preserved, so.
Argument that this material should come in for impeachment purposes?
Possibly. I think it depends exactly what, again, it would have been, because they would have had to have shown, we asked CS this question directly, she said no, and so now we're offering this exact statement from Mr. Cotner to impeach her, and then usually, they would probably, the state might ask for a limiting instruction to say this goes to her credibility only, not substantively, you can't consider it. So it's possible, but again, those arguments weren't made, so we don't know exactly what purposes they wanted that information in. But as we said, regardless, even under those two instances that were objected to, even if they did come in, the transcript is clear that Mr. Cotner was able to present his entire defense, and the jury was able to weigh that information, so there really was no prejudice here, and we think the court could just settle the issue on that alone without needing to get into any further arguments on the specific merits. But for those reasons, we would ask this court to affirm. Thank you.
Please.
The state mentioned a federal case law where even the right to present a defense needs to give way to standard evidentiary rules. And so I'd like to talk about Holmes a little bit, cited by the state. Holmes recognized that arbitrary application of rules of evidence are not permitted to abridge the right to present a defense. And while that case was looking more at the probative value of the defendant's evidence versus the prejudicial effect, it also has application to harmless error. What that case said is you cannot judge harmless error or admission of the evidence just by looking at the state's evidence, because there are two sides to each case. You need to consider all of the evidence. And the problem here is the jury never got to consider all of the evidence because of a categorically incorrect hearsay ruling. I want to also give you a record citation. No, there wasn't reporting on the bench conference. However, on volume 3, pages 217 to 218, we do have the defense attorney basically explaining what happened in the bench conference in response to the state's point of Mr. Cotner not mentioning that CS had invited him up to her apartment in direct. And the defense counsel says, and that's because you would have had to say the words that she told you, correct? Correct. Okay, I kept telling you, don't tell me what she told you, right? Yes. And that's because the prosecutor objected when you were talking about what she said, right? Yes. So you couldn't testify about that because that's something she said, correct? Correct. It was a definitive ruling. I do want to briefly point the court in the direction of Chambers from the U.S. Supreme Court and the State v. Wyckoff case I provided to the court. Chambers is helpful, not only for its discussion of the right to present a defense, but its discussion of what prompted the hearsay rule to begin with, and that is unreliability of out-of-court evidence. Out-of-court evidence that was not under oath, an out-of-court statement not under oath, where the declarant was not subject to cross-examination, and where the trier of fact had no ability to determine their demeanor. Yes, we have an out-of-court statement not under oath here, but both CS and Mr. Cotner testified at trial, and the jury could have examined both of their demeanors in determining jury credibility, and it is the jury who has the duty to determine credibility from all of the evidence, as the state acknowledged in its own rebuttal. The state acknowledged this was a case about credibility.
Real complaint, though, just that you don't like that 501 D2A is asymmetric as far as the defendant's statements come in and the victims do not?
In the sense,
Behind your argument on that, but I don't think that's a problem we're equipped to fix here.
no, and it's not a direct attack on 801 2D, whichever it is. It's more of the traditional parties get to contradict the other person's statement.
Gets to the impeachment of Wyckoff, and here she wasn't asked, like, did you want to go up to his apartment? Didn't you tell him you wanted to go up? There wasn't contradiction.
No, but then, the state opens the door to the invitation evidence. So at that point, he has to get in that, yes, she did invite me. And we cannot know how the court's ruling limited the defense's presentation of the defense. The idea that the defendant was going to essentially sandbag by not creating a record, I don't know of any defense attorney who would do that, because you want to present your case to the jury and not hope for a better verdict on appeal. So I would disagree with that. And the fact of the matter is, CS did give inconsistent statements regarding her drinking, regarding who she was with prior to meeting Mr. Cotner, and having discussions with him about his information and providing it to police. So for those reasons, we would ask for a new trial or preservation for PCR.
Thank you very much. Thank you, counsel, for the excellent arguments today and the briefing in this case. 250664 is submitted for our consideration, and my colleagues and I will have a decision out as soon as we can. Thank you very much. All right, our final case for consideration with this panel is 251373, St. Mary's Catholic Church and I can't say it. Diocese of Davenport and Guide One Insurance versus Ronald Hodges. Mr. Neal, you will be arguing for Mr. Hodges, and Ms. Cooper Nelson for St. Mary's and crew. Thank you. Whenever you're ready.
Court, counsel. My name is James Neal. I'm here on behalf of Father Ron Hodges. And I think this case essentially, comes down to an interpretation of an Iowa Supreme Court case, beer glass. And the commissioner in this case, he found that beer glass applies in this case, even though Father Hodges was paid weekly indemnity benefits prior to entering an agreement for settlement. So I want to start with beer glass, and specifically, the statute that applies is Iowa Code Section 8526-2. Now, there are two subsections to 8526. One, which is 8526-1, deals specifically with original proceedings. And that statute specifically states that an original proceeding must be commenced within 2 years from the date of the injury, or if weekly benefits are paid, within 3 years from the date of the last payment of weekly compensation benefits. Now, while 8526-1 deals explicitly with original proceedings, Iowa Section 8526-2 explicitly and exclusively deals with review reopening proceedings. And as such, that specific section says that the proceeding must be brought within 3 years from the date of the last payment of weekly benefits made under the award or agreement. So I want to emphasize the closing 6 words of Iowa Code Section 8526-2, for they are critical to, and in fact, I think determinative of a proper understanding of Father Hodges' argument with reference to beer glass. Those 6 words explicitly narrow and limit the origin of weekly benefits, which the statute permits to trigger the running of the limitations period, to those weekly benefits that must be made under an award or agreement. In that regard, I would submit to you that in its attempt to distinguish Father Hodges' case from beer glass, the district court simply read those 6 words, made under the award or agreement, out of the statute. And specifically, page 5 of the ruling of the district court, the district court judge said, in the present case, the respondent, Father Hodges, was paid weekly indemnity benefits before the settlement agreement via temporary and permanent disability. The last payment of weekly indemnity workers' compensation benefits was paid on March 5th, 2015. The statute of limitations, therefore, was on March 5th, 2018. Beer glass does not apply to the present case because weekly benefits were paid. She goes on to state Iowa Code Section 8535-2 clearly states that the clock begins running on the date of last payment of weekly benefits. this interpretation of beer glass would totally nullify the within 3 years from the date of the last payment of weekly benefits language of section 8526(2).
I tend to agree with you that those last words are important, and I think they're helpful to you on this first issue. If I could take you kind of to the second issue and the idea of payment in lieu, or payment in lieu of salary in lieu of compensation, I wonder, I struggle with that argument. You know, when we have no statute or rule or case that directly deals with that, and I know we cite there's a rule cited, but to me it doesn't seem like it applies to this situation at all. So how is it, you know, when you're talking about this situation of reopening after an agreement and where the statute that we do have is payment under the agreement, you know, how can salary paid afterwards ever be from that agreement? Is my question making sense? You know, so the agreement, you know, said the amount that he's owed is stuff that's already been owed. It's done. There's over, but you still get medical benefits. So it would seem like those are all the things that are payment under the agreement. How can salary paid, you know, roughly 3 years later be a payment under the agreement, like for purposes of the salary in lieu argument?
Honor, and I'll try to answer that. So the salary or wages in lieu of workers' compensation benefits doesn't come under the agreement. What the agreement does, and what Beer Glass did and the court did in that, was they talk about the legislative changes that were made to the statute of limitations in the 70s. And what they said specifically was the legislature knew what they were doing, and they switched the word compensation to weekly benefits. And so what Beer Glass finds is that medical is sufficient. Now, I know Beer Glass didn't deal with weekly benefits, but I think it applies because, of course, in Father Hodges' case, his medical was open. It remained open. He was still entitled to those benefits. So the medical portion is very similar to the Beer Glass case in that it was made under that agreement. Now, I understand the benefits that were the indemnity benefits came before that, but I think if you take the liberal construction of the workers' compensation statutes in favor of the employee, then the medical should keep that statute of limitations open from 3 years from the date of that agreement was approved by the commissioner, which...
Commissioner's basis, though, I didn't see anything about saying the medical payments that were ongoing was what kept it. I thought it was, you know, the diocese allowing the father to take leave at full pay. I thought that was the salary in lieu of benefits. So how is that connected to the agreement as a payment under the agreement?
Yes, Your Honor. So the agreement would allow the statute of limitations to be open 3 years from the date of its approval by the commissioner, which was November 23rd, 2016. So you have a 3-year period that you're looking at after that period. And so any payments that are wages in lieu of, which is an administrative rule that the agency creates, and by law they're allowed to do that, and they're given a little greater deference in their interpretation of their own rules. What that does is that essentially states that any work comp benefits paid within that 3-year period from November 23rd, 2016 would then keep that claim alive. And so Father Hodges in this case, so he has 3 years from that. And if you take 3 years under Beer Glass to be November 23rd of 2019, then the question is, was he paid wages in lieu of work comp benefits within that period? And so our argument, Father Hodges' argument, is he was, because he was unilaterally taken off of work by the diocese from February 1st, 2019 through June 30th of 2019. And during that...
Follow their kind of established sick leave policy anyway?
They have a policy, but the wages in lieu of, and this comes from the Moffett case, it's an objective standard. So there is no subjective basis that the employer has to intend to pay work comp benefits directly. It's just whether or not the benefits were paid. Father Hodges, the spokesperson or the person who testified for the diocese, Tierra Hatfield, they both agreed that he was paid his salary during that period. So on the objective test, there's no question that he was paid during that period. Then the question becomes, was he off of work because of the work injury? And the district court, and I don't think Appleese, they dispute that, that they knew that it was work-related. The question is whether he was off. And he was off on doctor's restrictions. The authorized provider, the doctor who did the last 2 surgeries prior to his time being off, Dr. Payday, had him on restrictions for a period, I think it was the latter part of 2018, up through, I think it was November of 2019. It's in the record. He wasn't off of work or on restrictions for any other condition. Appleese will talk about these other conditions, but it's clear, although her testimony was convoluted, Ms. Hatfield even agreed that in her testimony that he was off because of that work, because of the work injury. And so when you meet that threshold, again, it's just an objective standard. Was he paid these benefits during his time off? And we would argue that the reason for that time off was because of his work injury. I see my time is about up. So I would just ask this court to affirm the commissioner's decision in its entirety.
We'll have time on rebuttals, so thank you.
Good afternoon, Your Honors. May it please the court. Mr. Neal. My name is Taylor Cooper Nelson, and I represent the Appleese in today's case, St. Mary's and the Diocese of Davenport. As you heard from Mr. Neal, there are really 2 main issues in this case. We think the biggest issue is the statute of limitations. It's dispositive. If you affirm the ruling of the district court, there's no need to even get to the wages in lieu issue, which we disagree with the commissioner with as well, and the district court found that he was not paid wages in lieu of comp either. I'm going to start with the statute of limitations issue. I think it's pretty clear. I think the district court did a good job of explaining that it's plain letter law, it's black letter law. The statute says 8526(2), an award for payments or an agreement for settlement may be reviewed upon commencement of reopening proceedings within 3 years of the date of last payment under the award. That's what the legislature chose. That's what they put in there as a triggering statute. So to recap the timeline Mr. Neal mentioned, the last payment under that agreement was issued on March 5th, 2015. The plain language of the statute would have that statute of limitations 3 years later.
So does that mean, under your reading of the statute, if a case is progressing on for a long time, it's fighting, and eventually it's settled more than 3 years after the last payment, that there would never be a reopening, or that the reopening could, vanish within 30 days if it was just barely, after the last payment?
In theory, I think there's limited circumstances where you would settle, where you wouldn't have another payment, because I don't know what the claimants would get out of that settlement. So typically you have either a very recent payment with the settlement or a payment you're going to make pursuant to the terms of the settlement. So I don't think, if that situation were to arise, then yes, it would, the plain letter language would apply there. But I have not seen that before.
Subsection 2, add or agreement, where subsection 1 does not. It just stops at weekly compensation. And what's the significance of the word agreement there?
I think it's because subsection 1 deals with an original proceeding, and this is, so if you have an agreement or a settlement, you already know you have a compensable injury, so you'd move on to this section 2, and the section 1 no longer applies. By reading the plain language of the statute, Father Hodges' benefits, or his statute of limitations would have run on March 5th, 2018. Almost a year later, after the statute ran, is when Father Hodges was placed on a leave of absence by the bishop. At that time, the only work restrictions he was under related to the work injury in question was that he was able to use an electric scooter while at work, which he was able to do. None of the parties dispute that he was working in his full capacity at the time of the injury, and there's certainly no argument or evidence in the record that they couldn't accommodate the restrictions. Father Hodges and Tiara Hatfield, which was the HR director at the diocese, testified that, well, I guess I'll start with Tiara. She testified her understanding was the leave was to allow Father Hodges to heal from all of his ailments. In addition to the work injury, he had a number of other medical issues he was dealing with. I believe diabetes, cellulitis, all these other things he was struggling with. And at the arbitration hearing, he testified part of his understanding, part of the reason the bishop took him off was because his parishioners were concerned about his well-being, so the effect that it was having on them.
Does anyone's subjective understanding of the leave matter?
I mean, I guess the subjective, I mean, ours, I guess, the people that are deciding the case, because what they're trying to argue, what Father Hodges is trying to argue, is that he was paid wages in lieu of comp, and part of that analysis, I think, involves that, whether he was off due to the work injury.
Weighing those, is that really what we're doing?
Yes, to figure out, that's why I think when the commissioner mentions an objective standard, and I'll get into that, it's misused, it's out of context from the case that it comes from, because I think inherently this is a subject, you have to understand why he was off due to the injury. That's kind of a subjective analysis when you have so many things going on. So when the statute of limitations, so Buyer glass, I'll get into that a little bit, or I call it buyer glass, beer glass, so whatever. So the commissioner used buyer glass here, and we think inappropriately, and the district court ruled that was an abuse of discretion here, because buyer glass doesn't apply to this set of circumstances. Buyer glass is confined to a limited subset of cases where there were never any indemnity benefits. If you don't have any indemnity benefits ever paid, but you have an award or a settlement, there's no direction from the legislation on when does the 3-year clock start. And the reason you would have an agreement or an award where you don't have indemnity is sometimes, like in the buyer glass case, the claimant had a work injury and went to arbitration hearing where they found that he did have a compensable work injury, but he didn't lose enough time from work to be entitled to any benefits. So he was awarded medical expenses and ongoing medical, but no indemnity. So he has an award, but no payment to go off of. So I think buyer glass only applies to those situations, which is not the situation here. We have a definitive date here of a last payment. It's explicitly in the settlement that Father Hodges signed, and the commissioner himself, the same commissioner, signed and approved himself as well. And I think that it was just, unfortunately, an attempt to ignore the statute of limitations. The legislator chose that for a reason. If you were to, reading approval of an agreement as the trigger event would just replace the language the legislature already chose.
Seat, how do you describe buyer, bayer, whatever it is, glass? Are we distinguishing it? Are we concluding it's not applicable? What verb goes with it?
Both. I think it's distinguished because it's not, and it's not applicable because in that situation, no indemnity benefits were paid, but we had an award. And here that doesn't apply, we had indemnity benefits. I think that only applies to a very limited set of circumstances where that happens. Like I said, I have never seen that, but of course it does happen sometimes. So very quickly, my time is running. I'll move on to the wages in lieu issue, which again, I think the statute of limitations question is pretty clear. I think it was, there's an abuse of discretion, obviously, as the court found, for the commissioner to apply buyer glass here to move the statute of limitations somewhere that it shouldn't be.
Technical question on this. It sort of rests on the Commissioner's Moffett case, the party's argument about this. And that's an unpublished administrative case. The parties don't cite to a Westlaw citation for it, and I haven't found it, and it doesn't appear to be on the Commissioner's website of old cases. Is it? And I didn't see it in the record anywhere. Where is the case?
And I also had to call when we had the appeal, I had to call the court and somebody emailed it to me. So I can certainly, if there's a way to get that to you guys, or I don't know, put it in evidence or something, but there is a way to get it.
Procedure that says when you have an unpublished administrative case that's not cited to a readily available place, it needs to be attached to the party's brief. So I do think getting it in would be appropriate.
I'm a little concerned about doing that at this stage of things, and I'm sure you can imagine why. This is sort of a recurring issue, so this is not a comment just about you, but it puts us in a bad spot with these cases where they're agency decisions. We don't have the underlying record. We sometimes don't even have the reasoning. So my question to you is, should we even be relying on it at all?
Absolutely not. I don't think Moffett applies here. If it does, there's three elements. The first one is that the employer was aware of the injury. We know that. We can see that, obviously. The second two, Father Hodges doesn't meet, whether he was off work due to the injury. Not in part because of the injury, due to the injury, he was not. And the second one of whether they paid wages in lieu of benefits they would otherwise be obligated to pay, they weren't obligated to pay any. He was not under the TTD and healing period statutes. You're owed benefits until you are capable of returning to work substantially similar. He returned to work, was working full duty under those restrictions, and for that reason, we ask you to affirm.
Rebuttal?
For the record, I don't know if it's beer or buyer either.
If that Moffett test appears anywhere where we can use it?
Your Honor, I do not think it is in the record, but I would agree with Applebee's counsel that we'd be happy to attach it or file that decision for you guys. If you guys are, if you're able to accept it, we'd be happy to file it. And I do think that, I guess I don't, oh, sure, Your Honor.
Framing of the Moffett case is correct.
I will concede that my understanding is it's an agency appellate case, and I don't think that the appellate courts have decided on that at all. At least I couldn't find it in my research. So I do think it is only an agency case. But again, it is dealing with an agency rule of which the commissioner is able to adopt and interpret his own rules with pretty decent discretion or deference from the courts. But again, I'd be happy to get that to you guys if you do want it.
And here's my concern is, I'm not sure there is any weight that should be put on the agency's decision in this. And here we have, it's kind of plopped into the district court opinion, it's plopped into both of your briefs, and here we are chatting about it, and we don't even know what the decision says. So alleviate my concerns if you can.
I think the only way I could alleviate your concerns is, I guess, with a professional statement that the case does exist, and that if the parties are agreeable, we would be agreeable to getting that to you guys.
Putting it in the record at this stage of the proceedings, which is, if not across the finish line, at it, sufficient to cure the problems I'm concerned about?
I think that given the multiple references to the decision in both the Commissioner's appeal decision as well as the district courts, I think it would probably be in the court's best interest to have a copy of that. And if
District court had a whole copy, or if they were just quoting stuff from people who were quoting stuff,
I don't know, Your Honor.
That's concerning, right?
And I can tell you that I don't believe it's in the district court record.
I looked and haven't found it either, so if you think it is in there, tell me and we'll keep looking, but.
I don't think it is, Your Honor. Yeah, yeah. But again, we would be happy to get that to you guys if you guys do want it. And just to follow up with what the appellees argued, one of the things that I do think is important in regards to this wages in lieu of issue, again, I would just reiterate that the record is devoid of any other restrictions that Father Hodges was on except for his work injury. And, you know, also too with that, and this is, again, I think only an agency decision, but in order for you to be entitled to temporary total disability benefits, and that's what these benefits would be that we're talking about in wages in lieu of, you have to show that work was offered and that the work offered was suitable to the claimant's restrictions. And there is also a third prong, I'm finding it, bear with me. Okay, this comes from, it's an agency case, Brodagen v. Nutraject Systems. It's cited in appellant's brief. But the elements are the work was offered, the work was suitable, that is having a physical or mental demand level that does not exceed claimant's capacities, and that the refusal was an intentional act. And in this case, during that period from February 1st, 2019, through June 30th of 2019, the diocese did not offer Father Hodges any work, so therefore they can't even meet that first element that it was offered, and it certainly was not refused by Dr. Hodges, or Father Hodges, I apologize. My time is up. We would respectfully request that the court vacate the district court's decision and affirm the commissioner's decision in its entirety.
Thank you very much for those interesting arguments and also the briefing that we've received from both sides. It was very helpful. But for the fact that we were missing some things, but anyway. So we will consider 25-1373 submitted, and we will get out a ruling as soon as we can. Thank you. We're not going to advise you on how to proceed from, from your standpoint of this case, all right? Okay. Yep.
All rise. Hear, the Honorable Iowa Court of Appeals is now adjourned. Cotner and Associate Judges Aller and Bating of the Iowa Court of Appeals. The Iowa Court of Appeals is now in session.
Seated.
Good afternoon. Welcome to the Iowa Court of Appeals afternoon session. Today, this afternoon, we'll hear two cases. The first case is Knapp versus the State of Iowa. It's case 25-1186. Appearing on behalf of the appellant is attorney Molly Hamilton, and on behalf of the appellee is attorney Aaron Redenbaugh. So Ms. Hamilton, when you're ready.
Please the court and opposing counsel. The plaintiff appellant, Jacob Knapp, is requesting this court reverse two rulings entered by the trial court. The first ruling was the trial court's partial dismissal of all claims unrelated to care provided by Ms. Van Sickle, entered on March 26, 2024, and the second ruling that dismissed the plaintiff's entire case entered on June 22nd, 2025 for failure to comply with Iowa Code Section 147.140. Just as some minor background of the case, the plaintiff, Jacob Knapp, brought this medical negligence action against Brittany Van Sickle, who was a nurse anesthetist at the University of Iowa. The underlying allegations are related to a surgery that Mr. Knapp had at the University of Iowa, during which Ms. Van Sickle was the main anesthesia provider. And the allegations of negligence relate to some mismanagement during the perioperative period of his blood pressure that caused him to wake up from surgery with near complete vision loss.
Agree that your petition only alleges claims against Ms. Van Sickle?
Correct. When it was initially filed, Ms. Van Sickle was the named defendant, and then pursuant to the Tort Claims Act, the state of Iowa was substituted in. Within the body of the petition, the specific allegations, anytime an allegation of either negligence was alleged, a standard of care violation was alleged, that was made in only reference to Ms. Van Sickle.
You never filed a motion to amend the petition to add other defendants or other claims of negligence against different parties?
Correct. By the time that the partial dismissal was entered, an amendment had not been, a motion for amendment or leave to amend had not yet been filed.
If we agree with you on the first issue and say that the district court erred in granting that dismissal, but disagree with you on the second issue and we remand, what would be left of your case? What are we remanding?
I think it would be remanded back where I don't know if the timelines would be reset that would allow, a motion to, I guess, amend or leave to amend. And then I guess the trial court would then have to actually hear that motion again and potentially deny that, putting us potentially back here again, I guess.
Sickle's the only defendant, and by operation of 669.5, that became the state, right? And you haven't added any additional defendants, even though you named some in the petition, right?
They are mentioned and they are referenced because at the time Doe had not come down yet, and so there was a question of, is fact specifics, that heightened pleading still required? Right.
So going back to Judge Bating's question, if we were to agree with you on the first issue and say it was inappropriate for the court to essentially issue a dismissal order of some sort against defendants who aren't even parties to the lawsuit, but disagree with you on the certificate of merit issue and find that your certificate did not substantially comply, so the claim against Ms. Van Sickle and now the state has to be dismissed, there's no longer any defendants left in this lawsuit, right? So wouldn't the remedy have to be to affirm the dismissal of your lawsuit, but it would just be a different dismissal and that it would only be against Ms. Van Sickle as opposed to the other 19 folks? Because what's left of the lawsuit if we kick it out against Van Sickle?
I mean, correct. I think you're correct. It's a little bit difficult because it was almost like it was an advisory opinion that at the time that it was entered.
And say, yeah, you shouldn't have dismissed via this advisory opinion to dismiss claims against these people that aren't even parties to this lawsuit. That's fine, but the defendant that is there, if we rule against you on the certificate of merit issue, that claim against that defendant has to be dismissed. That's the only defendant. Case has to be dismissed, right?
Correct. And it may not be good for me, but it may be good for someone else. I think this is a repetitive issue somewhat.
Because we can't just remand it and basically let it sit there with no defendant with the idea that, oh, maybe you'll want to amend to add a defendant. I mean, we don't do that, right? I mean, that wouldn't be the way to go.
Correct.
Okay, thank you.
Has the statute of limitations run against any other potential defendants for this particular medical care?
And that was the timing of when the defendant filed the partial dismissal, was that it was filed, I believe, within maybe a few days or weeks of what would have been the underlying statute.
But you got your, went through the state appeals board on all 20 people, right? The one that was named and the 19 that weren't named as defendants?
I couldn't tell you if every single one of the other 19 specifically were, but a number of them were placed within the state tort claim.
Thank you.
You raised some claims below about the timing of the second dismissal, and you've not renewed those on appeal, have you?
I'm sorry, could you maybe clarify your question?
And let me find it here. I think that you argued there was some waiver and estoppel issues with not bringing the certificate of merit issues earlier. You're not reprising those on appeal, are you?
Correct. I think the Supreme Court has pretty ruled clearly on some of those estoppel and waiver issues of when those bright line rules are as to when a defendant must bring this by the dispositive motion deadline. And I think some of the other estoppel arguments have been ruled on by the court.
I'm sorry to keep peppering you with issues. You're not getting into the groove of your argument at all. But I just have a factual question for you. It seems like there's two different certificates of merit from Campbell in the record. There's one at pleadings, page 2144, and a different one at page 1752. One is shorter and one's a little bit longer. Do you know why there's a difference?
I believe initially there was one that I did submit with the state tort claim. That was shorter, and then I believe the second one was the one that was filed pursuant to the actual deadline after the case was filed.
Okay, thank you.
But I do believe that, both were served in the course of discovery, and the second longer one was, filed timely according to the statute.
Okay, thank you.
And just, I guess, moving forward, because I only have about 2 minutes left to the second argument, I think the plaintiff appellant feels that the trial court erroneously ruled that the certificate of merit was either didn't comply with 147.140 or that the trial court overlooked that it substantially complied. And the plaintiff's argument relies mostly on the idea that the trial court, I think, either misinterpreted Banwart and State of Carter, in that it just, I think, created a false dichotomy of that in order to comply with the certificate of merit statute, that a plaintiff must either fully comply perfectly with 622.1 or must have a fully notarized affidavit in front of a notary or other officer that is authorized to swear a statement. And so the trial court overlooked the fact that the plaintiff's certificate of merit had the language required of under penalty of perjury that has been, that the Supreme Court has noted in Miller, in Banwart, and that is the operative language that binds the conscience of the expert, and that subjects them to perjury. The argument that I think either the date or a statement that the facts are either true or the statements are true, I think really can be disposed of by the State v. Carter case in looking at the fact that the individual was not convicted of perjury because of the lack of perjury, but still had all of the other similar operative language, meaning it was dated, there was a certification, the statements were true, but the court did not uphold the perjury conviction because it lacked the under penalty of perjury, and that's the important language.
22.1 provides a specific example of the certification that would meet the statute. Is there some reason why that wasn't used here? I mean, wouldn't that be the simple route is, hey, the statute tells us what to say, let's use that?
My time is up, so can I just briefly finish? Yeah. I think at the time that the certificates of merit were being utilized, there still was, we didn't have the benefit of a lot of these, and so the statute does talk about the need for under penalty of perjury, and so that's why that was the operative language that was included.
Additional 5 minutes on rebuttal. Thank you. Mr. Redenbaugh, when you're ready.
May it please the court, counsel, good afternoon. My name is Aaron Redenbaugh, and I represent the state of Iowa on behalf of the University of Iowa Hospitals and Clinics. And we're asking that this court affirm the findings of the district court that the plaintiffs failed to substantially comply with their certificate of merit requirements. I'd like to move directly into the second issue first, because I believe that issue is dispositive of everything. And that is in terms of whether or not Mr. Campbell, the nurse anesthetist who served a certificate of, or a purported certificate of merit affidavit in this case, whether or not he substantially complied. And the key analysis hinges on
sense. I mean, you've still got the issue of, even if we agree with you on the certificate of merit issue, and based on along the line I was asking opposing counsel about, that it would probably need to still be a dismissal of the suit if the COM is bad. But we still have this issue of somehow dismissing claims against non-party defendants. I don't understand how it would be dispositive as to those defendants.
I'll just briefly touch on that. I believe the court's order was very specific, and it said, to the extent these parties have been named, a certificate of merit was not served, therefore they are dismissed with prejudice. If as counsel...
Certificate of merit requirement against non-parties.
The state of Iowa can be the only party, and it's no different than if you are serving...
The party once you follow the procedures in 669.5, right? So they could have amended potentially at some point and added any of those 19 people as defendants, and then there's hoops that need to jump through where the state gets substituted for those folks, right? But until that happens, why would the certificate of merit requirement be imposed with respect to people that aren't even parties to the lawsuit?
My understanding is that the state of Iowa is the only entity that can be named. There are several parties that were named when allegations of negligence implicated in the State Tort Claims Act, and then the council filed a petition that detailed the transaction of facts that implicated that care. I mean, one quick brief example, a lot of this concerns whether or not the prone position impacted the ultimate injury that the plaintiff sustained. There are several allegations in the petition that orthopedic surgeons, anesthesiologists were involved in the decisions to keep the plaintiff in the prone position. All of those directly relate to care of those care providers, and it's no different than if an entity or the hospital itself was served. You need to understand which is the care that is at issue, and so you would need a qualified expert
against the orthopedic surgeon or the nurse, whoever was responsible for leaving the patient in the prone position. There's no certificate of merit requirement because no claim has been asserted against that healthcare provider, right?
The claim has been asserted via notice pleading and a claim against the hospital via vicarious liability for that care provider.
Hospital, the state of Iowa got in there was through the substitution process of 669.5, right? I mean, the original suit wasn't against the state of Iowa, it was against Van Sickle. Is that right?
My memory is that I believe it was both Van Sickle and the state of Iowa, but
Well, and that might be the case under respondent superior, right? So they're going after the employer. But under 669.5, once the AG's office says, hey, this employee was acting within the scope of his or her employment, they have to substitute the state and take that party by name out, right?
how these cases are traditionally pled is that the state of Iowa is named. It was always improper to name Brittany Van Sickle, which is one of the reasons why we worked with the other side to get her removed. However, it was, again, via notice pleading, it is unclear who, or what was the extent of the allegations raised. And then, once again, just to try to truncate this, even if these individuals were not named as counsel alleges, the procedure would have been to file a motion to amend to insert them, which was never done here.
With you on that point, counsel, but the implications of your argument on the first issue concern me because I could certainly envision a situation where additional claims or parties were discovered after the certificate of merit deadline had passed, but within the pleadings window. So how would your argument impact that scenario?
First off, we know that scenario didn't apply here because based on the claims asserted against these care providers, they were aware of claims against those other care providers. Furthermore, the certificate of merit statute is not set up and arranged to allow for discovery to result in additional individuals. It's the opposite. The statute requires the plaintiffs to have their proof prepared early in the litigation and serve certificates of merits before discovery even takes place.
Position that the purpose of the statute, and I agree, is to kind of nip these cases in the bud early in the beginning, then how does waiting, I can't remember the exact time frame, but waiting so long to file your second motion to dismiss play into that? I mean, you knew those facts way earlier than you filed that motion, right?
The Iowa Supreme Court has recognized that the defendant gets to own the time for when they decide to file their certificate of merit motion, so long as it's done before the dispositive motion deadline, which was done here. So I just don't see how the reasons why the defense decided to move or not move is related to the analysis at hand.
Well, it was done after the statute of limitations passed, right?
Correct.
Yeah, okay.
So the certificate of merit time requirement is they have to file that certificate within 60 days of the defendant's answer, right?
Correct.
Okay. So walk me through this. If 6 months into the lawsuit, plaintiff moves to amend to add the orthopedic surgeon based on the claim that they left this patient laying in the prone position that contributed to his injuries. And the court grants that motion, so the orthopedic surgeon's now a named defendant. The procedure would be that named defendant is going to file an answer, right?
Correct.
Okay. And then the plaintiff would have 60 days from that answer date to file a certificate of merit as to that defendant, even though we're now 6 months into the lawsuit, correct?
Correct, but that's if you're only bringing in the named defendant. If you have an entity or if you have the state of Iowa who's potentially liable for everyone and they're being named at the outset, at the front end, you have to serve a certificate of merit affidavit from a qualified expert related to all of the care that could potentially be implicated, because that is the entire point, is to help winnow down the nature of the claims that the entity may be responsible for. Now, I realize I'm starting to run low on time. If it pleases the court, I would just like to switch back to the second issue, if only briefly, because again, I believe it is dispositive of everything. I believe that the recent order from the Iowa Supreme Court in the Rarick decision addresses the key matter at issue here, which is what it takes to comply with Iowa Code 622.1. When you are in a case such as this, where you are attempting to comply with a certificate of merit affidavit via an unsworn statement, Iowa Code 622.1 is the only option that a party has. And what the Iowa Supreme Court said to this is in the Rarick opinion, and it's on page 6, at least, of the Westlaw site, quote, under the plain and binding text of section 622.1, a document's legal significance does not turn on the beliefs of its signer, the reasonableness of those beliefs, or any other circumstance mentioned in Mr. Rarick's evidence. Rather, under section 622.1, a document's legal significance turns on the written contents of the document itself. Specifically, if the document is signed and dated, the sole question under 622.1 is whether the document states that the signer is certifying the document's contents to be true and under penalty of perjury under the laws of this state. If so, then the document satisfies section 22.1. If not, the document does not satisfy 622.1. It's undisputed under this record that Mr. Campbell's document lacked 3 of the 5 requisites that the statute requires, which is
Looking at substantial compliance here, though.
how the Iowa Supreme Court has framed substantial compliance is that as it comes to the affidavit, the oath is essential. If you go the sworn oath statement and comply, that is strict compliance. What the Iowa Supreme Court has said that if you go via the route of 622.1, that is substantial compliance. But you have to make sure, once again, that you have complied with the statute to render yourself under oath. And the statute has more requirements than just simply under penalty of perjury. Each of those requirements, again, under the plain and binding text of the statute, are requisite in order for an affiant to place himself under oath pursuant to that statute. So with that, I would ask this court affirm the findings of the district court. Thank you.
When you're ready.
Thank you. I think I'd just like to go back to maybe setting up the legislative intent in addressing some of the timing of if someone's named, how they're named, and looking at the purpose and intent of the certificate of merit. I think when the legislature initially passed this, it was one of the, I guess, goals of it was to decrease the cost of litigation and the medical malpractice or professional liability premiums. With that, I think, legislative goal in mind, that I think that's why the legislature looked at it on a defendant or party basis rather than a case overall basis, as to why a plaintiff can't comply with the statute by just serving one certificate of merit for their whole entire case, regardless of what the allegations of negligence are or how many parties are named. That is because the individual defendant is, I guess the assumption is the individual defendant or each party is going to be supported by one carrier. When you're looking at a party such as the University of Iowa, if the University of Iowa is substituting in for the individual providers, they are essentially the carrier. So whether one individual is named or additional individuals are named because additional information is discovered, that is essentially one carrier that's potentially at risk. So when it came to this case, there were certain things that that are not known and aren't known at the outset by the plaintiff. We don't hold the records. We don't hold information. There are only certain things that are exposed to us through the records we get pursuant to a request.
So explain to me how, it seems like to some degree, you guys did hear what medical malpractice defendants would want you to do, which is instead of just taking a shotgun and suing everybody, and then we'll sort it out later and we'll dismiss people as we figure out who we don't have a claim against. It seems like you did it kind of the way you thought you should do it, with more integrity of just we picked out the one we thought was the culprit, leaving room for the possibility that maybe there would be other ones that would come out through discovery. And there's also a selfish motive in there that you don't have to do certificates of merit for 19 or 20 people type of thing, but that's the side. If you did as opposing counsel suggests, where you just sued state of Iowa instead of naming Ms. Van Sickle directly, I'm trying to figure out how would the certificate of merit requirement work, since you have to meet specialties. You know, your expert has to be the same specialty as the defendant. Who's the defendant when the defendant is the state of Iowa? What's the state of Iowa's medical specialty? So then don't you have to get into, okay, this is the specific doctor that we made the allegations against, and this doctor is a nurse anesthetist, so we need that type of expert. If we then hit the orthopod and the surgical nurse, we would need people in their field to do a COM on them, right?
I think it goes back to what are your specific kind of counts of negligence, and then you get into the trouble I think that that the Shenandoah case had, is that there was sort of this default of like an individual, I think it was a nurse or a physician, and SMC and counts of negligence, and so were there separate allegations against the hospital, or was it all through like an agent respondeat superior that they got in trouble with? So I think it's changed maybe a lot of people's practice in that sense. But I think getting back to your question, there was also some factual issues in this case. It was a very complicated two-step surgical procedure case that was two separate orthopedic surgeons that did a actual like a fracture repair, and then it was a nerve repair, and it was a bit unclear of how this surgery proceeded. And then during the course of discovery, we realized that there was a pause during the procedure and some conversation amongst staff of maybe we should do this, maybe, you know, should we proceed? There was a lot of dispute that didn't appear in the medical record. And that was another reason why there was some issue with who to name initially and why Ms. Van Sickle was the only individual named. And then there was also some delay as to when these depositions were scheduled to occur after the request was made. There was efforts to get them done sooner, so we didn't run into a statute of limitations issue when that motion was filed, and that did not occur.
We will consider case 25-1186 fully submitted and will issue an opinion in due course. Thank you to both counsel for your helpful arguments and briefing. The second case to be heard today is the State of Iowa versus Krista Godat. Appearing on behalf of the appellant is attorney Ryan DeLucio, and on behalf of the appellee is attorney Louis Slovin. It's case number 25-1853. So counsel, when you're ready to proceed.
Thank you, Your Honor, and may it please the court, counsel. Good afternoon. My name is Ryan DeLucio, and I'll be arguing on behalf of the appellant in this case, Ms. Krista Godat. Now, Iowa case law is clear that the state may not unilaterally decide that a defendant has breached a plea agreement and then withdraw from that agreement of its own accord. Rather, the state is required to give advance notice of its breach allegation and its intent to withdraw, and then the district court must decide whether the defendant has in fact breached the plea agreement. Without that district court ruling, all we have is the state's allegation. So without a ruling, we can't say whether the state has met its burden.
This case has a little bit different fact scenario because the sentencing was set and then continued, correct, due to absence of defense counsel. So did your client not have notice at that point that the state was not intending to proceed with the plea agreement?
No, Your Honor. The transcript from that hearing that took place on September 25 is very brief. It's only about 10 pages long. At no point in that record did anyone, including the prosecutor, even so much as mention the plea agreement, let alone allege that Ms. Godat had breached that agreement, how she supposedly breached the agreement, and what the state's intended course of action was. they did discuss this allegation that appeared in the pre-sentence report that Ms. Godat had presented fake medical documents to the PSR author. But all that the state said about that was to briefly summarize what the PSR's allegation was, and then they said that is the state's position. The PSR, of course, did not opine on whether Ms. Godat breached the plea agreement, and it did not purport to make any sentencing recommendations on behalf of the state. So I don't.
Prosecutor's comment during that September 25 hearing, you mentioned it's 10 pages. On page 4, so we're early in the 4-page hearing, says, we'd like to go forward. She was not cooperative with the PSI process. That's the state's position. Given the fact that cooperation with the PSI process was one of the express conditions of the plea agreement, why is that not an indication that that's what the state's claiming when they say that's the state's position?
Because it does not actually reference the plea agreement. It doesn't tell defendant that, hey, we think that this not only is uncooperative behavior, but this amounts to a breach of the plea agreement. And then again, it still doesn't tell Ms. Godat what the state intends to do, if anything, about this alleged breach. And that's, if you look at the ABA standards for criminal justice that we cited in our briefing, they state that if the prosecutor believes a defendant has breached an agreement that has been accepted by the court, the prosecutor should notify the defense regarding the prosecutor's belief and any intended adverse action. Of course, those standards are advisory, but they have been cited with approval in prior Iowa Supreme Court cases, including State v. Hornis, State v. Ashan, and State v. Kuchenreuther. And so here, I don't think that the state's just quick reference to the PSR amounts to adequate notice under the facts here.
The district court must have had some inclination, because I think the language might not be exact, but I think they said to get to the bottom of this, and then also directed some of that documentation to be provided to the author of the PSI. And then there was a continuance, correct? Correct. All right. So at that point, your client did not believe there was going to be a problem with the plea offer?
We just don't know that from the record here. We don't know whether Ms. Godat had this notice or not, but I think
They getting to the bottom of then?
the PSR's factual allegation of whether these were actually fake medical documents or whether they were genuine. And I think that's why you see the district court emphasized when it granted this continuance, it said, I want you to provide those documents to the PSR author so we can get to the bottom of this. So really, I think the district court was just going to whether or not this was going to affect the PSR and its allegations. There was still no indication from the state as yet that it was going to change their position vis-a-vis the plea agreement.
You're not arguing that she violated, are you arguing that she didn't violate the terms of the plea agreement?
I don't think we can make that argument here, Your Honor, because, and that gets into our next issue, the district court just simply didn't rule on whether she actually breached the agreement. So because the district court didn't rule on that issue, we can't argue here on appeal whether some non-existent ruling is supported by the evidence in the record.
District court find that she was non-cooperative with the PSI, though?
The district court did find, again, as to the PSR's allegation, it said that that is no longer unproven conduct, meaning that the district court was then going to take it into account when it was imposing sentence. And given the context of that comment, that's exactly what the district court was doing there. I think this is on page 34 of the sentencing transcript. The district court had just imposed a sentence of imprisonment, and then it was explaining the reasons for that sentence when it gives this comment about, I don't find this to be an unproven allegation anymore. And then it goes on to say, and that's what tips the scales for me here in terms of imposing a prison sentence rather than probation.
Equivalent to finding that she breached the plea agreement, though?
I don't think so, Your Honor, because at a minimum, to determine the issue of breach, the district court is going to have to ascertain the relevant terms of the plea agreement. But the state is still going to have to point to what term does it think she breached.
Assume that the trial court doesn't know what's in the court file. They accepted the plea. The plea included the written plea agreement, which is filed in the court file. I mean, are you asking us to just assume that the trial court doesn't have knowledge of that, and that's not what the trial court's talking about?
From the record, it's not clear that that's what the trial court is talking about because it's not referencing that plea agreement anywhere. The district court, I'll note too, did accept the guilty plea because this was a 210 plea, but then it deferred whether it was actually going to accept the plea agreement itself. And so when the district court makes, again, this comment at sentencing, it's not engaging with the terms of the plea agreement on any level. It's not construing any ambiguity. Here I would say at a minimum, what constitutes cooperation versus non-cooperation. I don't think that's clear just from the face of the plea agreement. And then, of course, if the district court does find...
Did that last part, are you suggesting that submitting forged documents to the PSI writer, that's ambiguous as to whether that's a failure to cooperate with the PSI process?
I think we have to look at what is the PSI process, right? And here, this is...
Is that the argument you're making? Are you making the argument that submitting forged, false, deceptive documents to the PSI writer doesn't violate the term of the plea agreement that says the defendant will cooperate in the PSI process?
No, Your Honor, because I don't think we even get to that point here without the district court ruling on this issue. And so when the district court is going to look at, even if it does find this amounts to a breach of the plea agreement, I think we still then have to determine, is this a material breach that's going to excuse the state from its performance, or what are the terms that govern what happens next if we find that a breach has occurred? And again,
To a case that requires the district court to make that ruling at sentencing, that there is a specific finding that the state's withdrawing from the plea agreement due to a breach of the plea?
this specific issue I don't think has been explicitly addressed, because I think in all of the cases, certainly the state pointed to in its brief, State v. Foy, I think Hovind, Ashan, and this court's case in State v. Johnson, we do have explicit district court rulings there. And so this court or the Supreme Court on appeal were just deciding, is there sufficient evidence in the record to support the district court's ruling? And here, because we just don't have a district court ruling one way or the other, we can't review that.
Does it play into the analysis that this was a 210 agreement which bound the court? The court said, well, I'm not going to make a decision on that until we get to sentencing and I can see the PSI. And then the court announces that, like, I'm not going to be bound by, I'm not agreeing to be bound by this because I'm probably going to send her to prison. She's given a chance to withdraw her plea at that point, which the state points out she didn't even have the authority to do because she breached the plea agreement according to the state. And your client said, yeah, let's go ahead and let's go. I don't want to withdraw my plea.
And I think, Your Honor, that shows that the district court was not engaging with the terms of the plea agreement there. But in any event, whether, because this was a 210 plea, how that affects the issues here is interesting. I'm not sure that it does really make a difference for us here on appeal, other than I think it, again, just shows that in the record.
Got the sense that, I thought the state had to make a recommendation for probation, and now they're not doing that, and the judge just gave me the option of withdrawing my plea.
I think that
take it. Why is that not a problem for you?
It sounds like that sort of goes to the a harmless error analysis that the state suggested in its brief. But I think the Iowa Supreme Court has made clear very recently in State v. Patton that harmless error just does not apply in this context. We don't look at a no harm, no foul scenario. It doesn't matter whether the district court was likely unaffected by the prosecutor's breach or even explicitly says, I'm not taking this into account. The prosecutor's breach still leaves an indelible taint on the proceedings that we cannot excuse or overlook.
And what's the remedy?
The remedy, as the Iowa Supreme Court holds for prosecutorial breach of plea agreement, is going to be reversal and remand for specific performance before a different district court judge.
During that hearing, would the state have the opportunity to say, we're putting you on notice that you breached the plea agreement, so we're going to change our recommendation as the plea agreement allows us to do? Could they do that?
I see my time has expired, man. Thank you. That's not the usual remedy that the Iowa Supreme Court applies here. In some of the federal cases that we cited, that does get to be the remedy that gets applied, so I think this court could apply that here, but just the typical remedy under existing Iowa case law is going to be reverse and remand for specific performance.
I guess that's what I'm getting at, is what is the specific performance? Because the specific the agreement is, we'll recommend this if you do that. And they're saying you didn't do that, so we don't have to do this. Right? So what's specific performance in that situation other than to have a hearing on whether you did do that?
So specific performance would either be the state makes the recommended sentence of probation that it promised, or, as I said, federal courts do sometimes reverse and remand for the breach issue to be litigated where it wasn't ruled on below. So that's something this court could do as well and just say, we're going to reverse, let the breach issue be litigated below, let the district court rule on that issue, and then we can proceed from there.
Thank you, counsel. You'll have an additional 5 minutes on rebuttal. Mr. Slovin, when you're ready.
Thank you, Your Honor. May it please the court, counsel, good afternoon. It's a privilege to be here. I want to be really clear. I'll start where was left off. My argument is not that a prosecutor's breach of the plea agreement is ever amenable to harmless error. My argument is kind of precisely what was just said, that if you find that the problem is that the finding of breach was not made at precisely the moment when it should have been made, and you are thinking about remanding for a finding or for a finding of whether the defendant breached the plea agreement, that finding was made, as was pointed out. Very specifically, on page 27 of the sentencing transcript, I find the state has established, it's talking about the state establishing that she forged those documents and was not So what I'm saying about harmless error is if the challenge is just about the timing of when a finding of breach was made, not only do you already have that made here, but even if you think you didn't, from this record, you can say that it is obviously a breach. There's not really an argument being made here that there hasn't been a breach of the plea agreement. So that's what I mean by harmless error, that if it's a procedural error about when a finding is made, that is amenable to harmless error because you can look at this record and definitively say that error can't have contributed to the result. Now, I've heard a lot of really good arguments here about the need for an error preservation requirement. A lot of arguments about how the lack of a ruling below is precluding effective review by this court, and I'm sympathetic to that. But the reason why we don't have a ruling by the court that's more precise about the specific issue, resolving a dispute between the parties as to whether there was a breach, is because the defendant didn't claim that she didn't breach below. I mean, she was prepared for the hearing to litigate the issue, and she had her own evidence, but when the state made its recommendation and said, we believe that she breached the plea agreement, so we're withdrawing, there was no response from the defendant to say we didn't breach. There was no claim that there was no breach. The district court had nothing to resolve. And so to say that they don't have to preserve error, but the fact that the district court didn't make that particular factual finding means that not only is this error, but it's also unreviewable error, I just don't think that's defensible.
Even if we agreed with you, can we go there with our Supreme Court cases in this arena?
What you can't say is that there's an error preservation requirement that precludes the claim from being brought. What you can say is that, and you can follow Johnson, which I think our position just mirrors the paragraph from that case that we block quoted, that if the issue is raised, and this tracks the federal cases that say defendant's entitled to a determination on the issue of breach if there is a factual dispute. If the issue is raised, the defendant is entitled to a final determination by the court, but that final determination is not the thing that relieves the defendant or the state of its obligations under the plea agreement. The thing that relieves the state of its obligations is the fact of the defendant's breach. The state can then proceed and withdraw from the plea agreement, and then that can be ratified by a final ruling by the district court later if the defendant raises a challenge. If they don't, there's nothing to rule upon. And the fact the defendant can't later claim, the defendant can challenge the prosecutor's can allege a breach of the plea agreement and say, the prosecutor breached by withdrawing because I didn't breach. And in theory, under Davis and Bolden, they could raise that claim for the first time on appeal. But what they can't say is that I'm sorry.
I'm just wondering, it seems a lot of the appellant's argument is that the words were never uttered by the prosecutor, I am withdrawing this plea, and then the same for the district court, like I find you breached the plea. Does that affect your argument at all?
Yeah, I mean, I'm sensitive to that. So what I'd say is this court is right to point out that the state was saying verbatim the language that triggers the condition number 2 in the plea agreement. The state says our position is the defendant failed to cooperate with the PSI. I think that puts everyone on notice as to what the state's position is. It wouldn't matter that that's the state position for any other reason. Now, what I would also say is that at best for the defendant, what this record has is an absence of proof that notice was given, also an absence of any proof that it wasn't, absence of any claim that notice wasn't given. Right? It's not enough to say, and if the issue is that notice wasn't given and due process was violated, then you have to have some sort of, there's no requirement in our rules that notice has to be provided on the record. If notice was given off the record, then that would be sufficient. And yet there's no claim that it wasn't, there's no evidence that it wasn't, right? So this record, not having notice, doesn't establish it's not given, doesn't establish any error, even if that was a grounds for reversing. Now, I don't think that in our case law it is, and I quoted Johnson to you. Yeah.
Interrupt. Can I just ask you a more fundamental, basic question? Do you agree that the state has to give notice of its intent to withdraw from the plea agreement?
I don't. I think that there is a fundamental due process backdrop here, and Barker is the case that everybody relies upon. Now, Barker says it's the combination of two things. It's first the lack of proof that the defendant breached the plea agreement, together with the lack of notice that the state was going to rely on it. One thing that you notice is that when the state starts proving up the violation, there is notice and opportunity to dispute it. Even if that notice is not given in advance of the sentencing hearing, bless you, when the state goes through and lays out that proof, that is due process happening in real time. The defendant has an opportunity to dispute those allegations. And there's no way to say that the defendant wasn't prepared to do that when the continued sentencing hearing began. It was clear to everybody that that was the issue on the docket. Defendant came armed with a new stack of papers purporting to show that. So the defendant, even if you could say that at the margins, if the defendant is completely caught flat-footed and the state manipulated something to make that happen, some sort of freestanding due process claim, if that claim exists, it's not met here. The defendant had notice and opportunity to contest the state's very clearly stated position that she failed to cooperate, and the district court understood that to be the issue before it at sentencing and made findings to that effect.
Would you agree your argument might be weaker if that time frame in between the hearings was not there? In this case, notice, blank period of time to prepare for the hearing and a continued hearing. Had it all happened in one day, does that weaken the state's argument?
Yeah, I think that makes a due process claim stronger because it undercuts their opportunity to make use of the notice that they received. It's similar to, it would make it look more like Barker. But the situation that we have is that the state, the continuation of the sentencing hearing made it pretty clear what was left to be resolved at the sentencing hearing later. The district court made that finding that resolves the issue. And I would point out, there's not really a consensus among federal courts that a finding of breach has to be made before the state is relieved of its obligations under the plea agreement. In fact, I think the weight of authority supports the opposite proposition. I went to Livar, L-I-V-A-R. That's the Ninth Circuit case from 2024. It's cited in the appellant's reply brief as a per curiam, or I think it's their original brief. After the per curiam part, there's three separate opinions, all laying out some interesting takes on procedural rights and requirements. And the second opinion by Judge Van Dyke lays out that the majority of their sister circuits have said that it is the fact of breach by the defendant that relieves the government of its obligations under the plea agreement. Now, the defendant is entitled to a determination as to whether what they did actually constitutes a breach and whether the government is actually relieved of its obligations. But the government doesn't need to wait for that to act. The government can get its action ratified by a subsequent district court finding that breach has occurred. And that just makes sense, right? A lot of the time, these agreements contemplate dismissal and not refiling other charges. And as the defendant's reply brief points out in analyzing Hovind in the footnote, you can't get a district court finding of the defendant's breach before the state acts to refile those charges that had been dismissed. Why? There is no active case. The way that you get a district court to rule on the defendant's breach is the state refiles the dismissed charges, the defendant moves to dismiss, and then the state puts on its proof of yes, the defendant breached, here's how I'm gonna prove that. And so the court is ratifying the filing of those charges after the fact, after the state has made the unilateral determination that the agreement was breached, acts based upon that breach, and then the defendant raises a claim, disputes the state's claim of breach, and then the finding is made ratifying the state's action. Or the finding is made that the defendant has a remedy in that situation. That remedy is...
Interrupt again. Just going back to another basic question. There's case law stating that the state cannot unilaterally withdraw from a plea agreement, right? So what does that mean to you? What's unilateral withdrawal?
Usually what that means is a lot of times that statement is made in the absence of any claim of breach, that the state, it's kind of like Barris, where the state is kind of claiming frustration of purpose, unilaterally withdrawing because it just doesn't want the terms. The other way that it's used is a unilateral, like it is a way of asserting the district court's right to make a final determination. Sorry, thank you. The district court has the ability to make a final determination, and the defendant, if they ask for it, is entitled to a final determination on that issue by the district court. If they don't ask for it, I mean, if they hear the recommendation and then they don't argue that they didn't breach or they don't object or anything like that, what is there for the district court really to rule on? I think the district court here, admirably, still made the finding that I find the state's established, these were forgeries, this wasn't cooperation, but even if it hadn't, what you would look at is, I mean, the court has said, the sufficiency of the record at the time of sentencing to establish the defendant's breach. And they're kind of skipping right past the district court ruling, as you would expect from a court that has rejected error preservation for this kind of thing. So if error preservation rules don't apply, what's good for the goose is good for the gander.
The page number of the sentencing transcript where you say the court made those findings that you just quoted again?
Yeah, the first time it mentions that is on page 27, where it says, these don't look like discharge reports. The court finds the state's established that. And then later, it's in paragraph 15 to 27. That doesn't specifically say lack of cooperation. What the court is later saying,
says, well, normally I would hear from the defendant at this point, but before I do that, I'm going to tell you I have some serious concerns here. Is that the language you're talking about?
The end of that paragraph, and in that it's indicating that it finds that these are not genuine. And the state's, yeah. Okay, thank you.
Counsel rebuttal when you're ready. And if you would, I'd like you to start off responding to your opponent's argument that there's no indication that your client was surprised by the withdrawal at that second hearing.
Thank you, Your Honor. I think the record shows that she was surprised here because then when the district court offered her an opportunity to withdraw her plea, initially she said, yes, I do want to withdraw my plea. And it was only after the state then said, well, if you do that, we're going to reinstate this habitual offender enhancement, that she then backed down and said, no, I'll go forward with the process.
And then just one more follow-up question to that. In your initial argument, you asked for a remand and then possibly a hearing on the breach. Your client could possibly be facing the habitual enhancement, correct, on remand?
I don't think so, Your Honor. Under the terms of the plea agreement, if the district court does find that that was a breach by failing to cooperate, the plea agreement just says that the state can then withdraw its recommendation, but it doesn't say that the state can then reapply the habitual offender enhancement. And then we'd also have some concerns about, I think there's a line of case law about imposing a harsher sentence on remand. We have this sort of presumption of vindictiveness, and the state would have to overcome that there. So no, I just don't think that that would occur in this case, but we would have to see what would happen on remand. To the state's point about, it seems like they're arguing all of this would have been fixed if Ms. Godat had just objected on the record here, and that's why we need this error preservation rule. I think that flips the burden here, because when the state is alleging that the defendant has breached a plea agreement, it's the state's burden to prove that the defendant has in fact breached, and then the district court has to rule on that. It's not Ms. Godat's obligation to point out that the state has this burden and that the district court hasn't ruled on it. And
when you came back for the rescheduled hearing, not you, but the defendant came back for the rescheduled sentencing hearing, there's reference to defense counsel saying, I brought a stack of documents that I provided ahead of time so that the court, before this hearing, referring about the documentation problem. What are you claiming that she thought was happening that prompted her to bring this documentation to rebut the claim about falsified documents?
Exactly that, Your Honor. I think she understood, at least, and this is my interpretation of the record, at least, I think she understood that this was what the PSR was alleging and not wanting the district court to take that into account when imposing sentence, regardless of what the state's position was vis-a-vis the plea agreement.
Your claim is she brought this documentation just to rebut those allegations made by the PSI author so the court didn't hammer her on sentencing as opposed to as a basis for the state getting out from under its obligations under the plea agreement. But it was a 2.10, so that that couldn't have been a risk. Because she's either got probation under the 210 agreement. I mean, if the agreement's in place, and it's complete surprise to her that anybody's claiming that she breached the plea agreement, so we don't have a deal anymore, the joint recommendation is going to be for probation, and the court has to agree with that and go along with that, or give her the chance to back out, right?
Correct.
So, how could it be that she's worried about she's going to get hammered at sentencing when they've got a 210?
Because I think, the case still could have proceeded. The prosecutor makes the promised recommendation, Ms. Godat makes her joint recommendation, and then the district court again says, I have these concerns about these allegations in the PSR, so let's address those. So the district court still could have addressed that even if the state had not breached the plea agreement here. But I think, again, that kind of goes to this harmless error question. And as the Iowa Supreme Court has said, we just don't look at harmless error in this context. And this is why I think the procedure that we've outlined, notice, litigation on breach, and then a ruling by the district court is really what makes more sense here. The state argued that the weight of federal authority goes the other way. That's not the case. The Fourth and Tenth Circuits both hold that the district court ruling has to come before the prosecutor acts contrary to the plea agreement. The Ninth Circuit is the only case that holds to the contrary. But of course, that LeVar case was heavily fractured. There was one judge on that panel that said we should apply this timing ruling. The other circuits, I think, that we cited, they all hold that a district court ruling is required, but they haven't specifically addressed the timing component yet. So really, it's just the Fourth, 10th, and 9th Circuits that we're looking at on that timing piece.
If the state had formally notified your client that, hey, I'm withdrawing from the plea agreement because I think you breached it, what would she have done differently here?
We just don't know that because that's just not that's not the record we have. I think we could see that, she might have still brought these exact same documents. Maybe she would have gone and got additional witnesses. But also, if we had been on notice that there was going to be this legal issue of whether the plea agreement was breached, or at least a mixed question of fact and law, then maybe her counsel now has time to prepare a legal argument on that issue. I see that my time has expired. If I may briefly summarize. You may. Thank you, Your Honor. So for the reasons that we've argued here and those in our briefs, we'd respectfully request this court reverse and remand for specific performance before a different district court judge. Thank you.
Thank you. Thank you to both counsel for your arguments today and your briefing. It's very helpful to the court. With that, we will consider case 25-1853 fully submitted and will issue a ruling as soon as possible. With that, we'll be in recess until 10 a.m. tomorrow.
All rise. Hearing, the Honorable Iowa Court of Appeals is adjourned.